All right. I'm going to get us started. I assume some other people will move their way in, but I already see a great crowd, and I mean that both in numbers and in some familiar faces I recognize. So welcome. As the panel, as the display highlights, the panel here is sentencing second chances, addressing excessive sentencing with escape valves. I am Doug Berman. I'm a professor at say it all with me, the Ohio State University, Moritz College of Law, and we care about that, and I'm incredibly honored and pleased to be speaking at this conference and to have on this panel, going from the end towards me, Arthur Rizer from the Justice Policy Director at R Street. I would urge you to read everything that he and others at R Street have written, some of the really best, sharpest stuff in this space and others relating to sentencing. And then next to him between us is the Honorable Marilyn Mosby, the state's attorney for Baltimore, Maryland. I'm sure she's written a bunch of stuff. Just read what other people say about everything she does. The good parts are true, the criticisms are not, right? And I'm doing my best as moderator to make my panelists like me, especially if I do, as I often do, take too much of the time at the outset. But I had warned them that kind of my tour through our conversation is I was going to spend 10 or 15 minutes giving something of an ivory tower perspective on this issue, but then also work in the area that I've been paying a lot of attention to, which is the federal system and some recent developments, particularly with respect to what gets called compassionate release, but should be about so much more. That's a second look mechanism that's now been expanded in the federal system or altered a little bit in the federal system. I'll get to that. And then we're going to turn to Arthur and the Honorable State's Attorney Mosby to talk about some state level perspectives on this issue. And hopefully we'll save 10 or 15 minutes for questions and discussion, because there are people in this audience I know who have different looks at second looks. My ivory tower start to this, and it's an ivory tower start that's based on some of the writing I've done and some of my thinking about this issue. This is a constitutional issue, and of really interesting constitutional pedigree, because clemency is your classic second look doctrine. Clemency is built around, you read the Federalist paper, you see the framers talking about clemency as an important mechanism to enable a second look at a conviction that may have a problem, at a outcome in the criminal justice system that may be problematic. And of particular importance, I think, to be reminded of is it was the prerogative of the king. We had a revolution to no longer have a king in charge of our freedom and our governance, and yet the framers thought a second look in the criminal justice system was so important they would preserve in our founding document this king-like power of clemency. And we could, although I think there's a panel this afternoon that will look at least a little bit more at clemency. That's a topic that has had and merits a symposium all its own. The point is, in this context, to appreciate second looks, second chances in the sentencing system is not something, wow, that's strange and different. That's been with us from literally the founding and has had constitutional consequence from there. Another thing, though, to keep in mind, or that I've certainly written a little bit about and I think is worth integrating into this conversation at the outset, is we also, for the last 100 years or so, had another version of second look built into our sentencing system in the form of parole. Now, we don't have that in the federal system, and it's not that new that we got rid of parole in the federal system, but especially when we think about state systems, it's important to keep in mind that a number of states still have parole, although a number of states have gotten rid of it. Many have limited who's eligible for parole. But parole was built into our sentencing systems pretty widely over the last century because of a recognition that people change and that our sentences should be adjustable based on people changing. Often parole was also used, whether expressly or implicitly, to reflect how times change. That a change in circumstances, not necessarily just a change in an offender, but a change in circumstances, either related to the crime, related to society, should justify rethinking whether a prison sentence, in that case in particular, ought to stay in place. And I provide all that background because it's against that backdrop that we have to notice how much modern sentencing systems have been lacking. Many some in this room have written about clemency drying up at the federal level, at the state level. The use of clemency as a mechanism to achieve sentencing second chances, to do second looks, has been reduced. Some of that's political, some of that's other factors, but with clemency drying up, and parole, as I mentioned earlier, also has been repealed in the federal system, restricted in many state systems. And so it's not just a story of, is second look a good idea? It's how do we look at the way in which sentences get administered? And let's not lose sight of the fact that we're now at the unusual time when we don't have as many second looks built into our understanding of how a sentence will be administered. And of course, for me, thinking of this as an era of mass incarceration, an era of mass punishment writ large, that's a uniquely bad time to restrict second looks, right? We've gone in the wrong direction with respect to second look, and we've gone in the wrong direction with respect to the size and scope of our criminal justice system, a very bad combination. Wonderfully, giving the ivory tower perspective and then the federal perspective, there's some at least modest good news in this story. The model penal code. Talk about a pointy-headed academic thing to talk about. This is the thing that's been written by the American Law Institute. Years ago, you may have remember, if you're a lawyer in law school, learning about the basics of the model penal code. Well, the American Law Institute recently rewrote its entire sentencing chapter of the model penal code. Interestingly chose, I criticize this choice, to recommend eliminating parole. They think a model system doesn't have parole. I think that's a mistake. I can point you to one of my articles saying I think that's a mistake. But they recognized in the model penal code, if we're not going to have parole, we should have some formal second look mechanism built into the system. The way they recommended in their chapter on sentencing was an automatic right to go to court after 15 years and have a judge look at your sentence anew, to look at the basic theories of punishment and the ideas that the entire sentencing system is meant to achieve. And a couple points I want to emphasize about that, which is both in the history of the model penal code and worthy of extended conversation for anybody thinking about these issues. First and foremost, there's the procedural interesting issue of who should be in charge of giving a sentence a second look and how should they do it. And I left that out a little bit, though those of you familiar with sentencing systems understand. Clemency goes through the chief executive, the president, a governor, traditionally, although a number of states have clemency boards of various sorts, so it's a complicated administrative law story there. Seeing Rachel Barkow in the back, I'm always tempted to look at her when I say it's all of criminal law is really an administrative law issue, but this is one of those examples where it's not just the chief executive often who's in charge of clemency, true in the federal system certainly, but it has its own modifications there. State systems more complicated. Parole boards were developed, typically placed in the executive branch for doing parole as a version of second look. The model penal code is saying the second look should be a judge. It should go back into court. And they actually recommend the original sentencing judge. Whether we think that's a good idea, this is where academics can get very clever. Well, gee, maybe the second look should be a second judge, right? Maybe we want it to be almost like a much later kind of appellate review a little bit, the second look. And the model penal code doesn't get that deep into working through those particulars, but I just frame the issue of even if you think a second look is a really good idea, you have the procedural issue of who should be in charge and who should have authority to give that second look. And especially wonderful to have a prosecutor on the panel, because prosecutors have a variety of roles to play in fostering or opposing second looks in our system. And we hopefully maybe we'll talk about that a little later in the hour. Second, there's the why 15 years? And I know this was a big point of debate among the model penal code drafters, was like, well, how about after 10 years? How about after 25 years? How about, and I don't think anybody has a good answer to that, but it becomes yet another piece where procedure and substance match, right? If you really think, boy, we get our sentences wrong a lot, however you want to define wrong, you might want second looks to happen more frequently and repeatedly. If you think, no, we usually get it kind of right, we ought not have too many second looks because we'd undermine the deterrent value or the finality interest that might be involved in actually telling an offender this is what they should or should not serve. Those are all great, interesting questions the Model Penal Code drafters struggled with, came up with this 15-year mechanism. The next question, though, is, and the other question that I've been giving a lot of thought to in the context of the federal system, which I'll speak to just in a second, is what are the justifications? What are judges to be looking at when they do these second looks, or parole boards, or clemency granters, right? And again, one of the amazing stories of historic clemency power, especially at the federal system, but true mostly in state systems as well, is whatever the chief executive wants. You want to be nice to your family and friends? Apparently that's allowed in the federal system because there's no constitutional limits on how the clemency power is used. You want to announce, this is now President Obama's history, you want to announce here are our principles and have thousands of people apply and then in a mysterious way pick some subset of those people to get clemency? You can do it that way. And the rules and rationales are completely for the direction and control of the chief executive. That's been the history of clemency, both at the state and federal level, and rightly has been the subject of controversy and concern because of uncertainty about what standards apply. We just came from a bias session, what biases may influence that incredibly broad exercise of discretion. Think about parole boards. Parole boards generally, formally, were almost always tasked with just look at whether this offender has been rehabilitated and or poses a risk to the public. But that may or may not be the rationales and substantive justifications we think ought to entirely inform or even partially inform whether a sentence should get a second look, right? And especially staring at Matthew Charles in the audience, who I want to thank for all of his work and comments in all of this arena, things like, are sentencing laws changing? Or maybe not our sentencing laws changing, our attitudes changing. My favorite one here, I don't see Beth Curtis in here, but she's been a tireless advocate for her brother and other persons serving life sentences for marijuana offenses. Life sentences for marijuana offenses in 1980 were crazy then. They're really crazy when there are people making literally billions of dollars selling marijuana doing the exact same thing. And yet we don't have mechanisms, we haven't even really started to think through fully how to go about adjusting those sentences sensibly. And of course, part of the problem, it's part of the problem that Matthew Charles had to live through, that many others are still living through while in prison now. It's much easier politically to pass a statute to adjust sentences if you expressly say, this is only going forward. This is not retroactive, right? And so that's why I get to the last piece of the story, that's the First Step Act, and then have our other panelists speak on these issues as they see fit at the state system and other parts of this concern. The First Step Act has, I think, this wonderful little, not quite hidden, but hidden so far, it seems, in the courts, provision concerning what gets called compassionate release, but actually should be called the extraordinary and compelling clause, because there's a provision in federal law that has always said a judge has authority to modify a term of imprisonment, reduce a term of imprisonment based on extraordinary and compelling circumstances. The problem with that provision is historically it required a motion by the Bureau of Prisons. Only if and when the Bureau of Prisons made a motion for a reduction of sentence under this little tiny provision of federal law could a judge even consider whether a defendant had extraordinary and compelling circumstances to justify a sentencing reduction. Among other things, there were Inspector General reports saying the Bureau of Prisons spends a year even considering an inmate's request for one of these motions. The person literally dies while waiting for this kind of release. And much of the conversation has historically been about, well, maybe we as the Bureau of Prisons, if the person is sure to die within 6 months after we let them out early, maybe we'll think about making a motion in court. And wonderfully, usefully, because Bureau of Prisons was so terrible at administering this provision humanely, the First Step Act includes a provision that now says if the Bureau of Prisons does not address this motion within 30 days or denies the prisoner's request to have this motion brought, the defendant can go directly to court and petition his original sentencing judge, and all the judge has to find is that there were extraordinary and compelling circumstances to justify a reduction in the sentence. The concern I have is because of all of this history, judges are mostly getting these motions literally when somebody's about to die, or there are some language in a sentencing commission guideline talking about caretaking of young children. The thought is, oh, maybe we will do this in some cases. There's two parents, one of the parents dies, that parent was the custodial parent because the other one was in prison, and maybe we'd call it extraordinary and compelling to let this other parent out to do some caretaking of children as long as there's no threat to public safety. But I think if Matthew Charles hadn't been released thanks to the retroactivity provisions of the First Step Act, I can't think of anything more extraordinary and compelling than your story. And I know you know, I know there are dozens, not just dozens, hundreds, not just hundreds, thousands of stories. Now, I guess I find everything extraordinary and compelling because that's the language of the statute, but I'm hoping, among other things, and I've been working with Sean Hopwood on a brief that's trying to make the argument that not just extraordinary, compelling can and should mean whatever judges see it to mean, but that's what Congress intended in the first instance, that this was designed to be an effective second look mechanism to allow anybody who can make a strong argument to a judge and will develop a common law set of rules and standards about what that should look like, and that shouldn't be fretful. That should be something that judges should be embracing. I see a few judges in this audience that I think might be inclined to embrace it, and that advocates ought to be identifying not just ill prisoners in the federal system, not just caretaking parents, but any and everybody who can tell an extraordinary and compelling story. That's the language Congress put in place. If Congress doesn't end up liking how broadly that gets interpreted by judges, they can change the language. But I don't want judges not interpreting it broadly just based on a fear that that's not what Congress had in mind, because there's such a need for this kind of second look mechanism, especially in our federal system where we don't have parole, where we don't have clemency functioning in any robust way, where we don't have the kind of second looks that I'm happy to now shift over to my compatriots, because at the state level there's some exciting work being done in this space. Still not enough in my opinion, but I'll let you judge that after you hear from Arthur and the Honorable State's Attorney Mosby.
Thanks for you all for coming. I mean, I'm kind of starstruck up here. I'm with Professor Berman and S.A. Mosby, people that I really kind of look up to and I think are leaders on this issue. So I'm very honored to be here. My name is Arthur Rizer. I am the director of criminal justice policy at the Aleph Institute. It's a think tank, a libertarian think tank. So we want to privatize sidewalks, but at the same time, we want to ensure that the government's reach is as limited as possible. And there's nothing more powerful the government can do to you than say you're under arrest. And with that great power, we believe that as citizens, we should be ensuring that everything is held to excellence. And we obviously don't have that in the United States. I know you've heard statistics all the last couple of days, but think about these couple of things. Well, I introduced myself a little more than that. I'm a former police officer, both civilian, and I retired from the Army after 20 years in the reserves as an MP, and I was a federal prosecutor for 9 years. I was a law professor full-time for 3 years, and then now I teach part-time at George Mason University, UCL in England, and I just had an appointment as a visiting professor at Yale Law that starts next year. So think about some of these numbers. I know you know these, but it's important to keep this all in perspective. We have 5% of the world's population, 25% of the prison population. We have 2.1 million people incarcerated right now. And you can almost double that number for the people that are on some type of supervised release of some type. So what is happening with our criminal justice system? It obviously has the input has a big piece of this, right? How many people we are sticking into the system. But just as important, in my opinion, is how long people stay. We have these crazy long sentences, and we end up in a point where a vast majority of individuals that are incarcerated, I would say in the federal system where I was a federal prosecutor, it doesn't serve any of the purposes of the criminal justice anymore. I have no problem with punishment being one of the pillars of the criminal justice system, but it should be a pillar, not the pillar, which is what's seemed our entire apparatus has been built around. So the function of the criminal justice system, the problems that we have really revolve around how long people stay. So even though that crime rates that are all-time low, and 36 states have actually decreased their prison population, the extreme lengths that we have, and the narrow mechanisms we have for releasing people on second looks has really limited our ability to get people out. And so what's actually happening is our prisons aren't just for the individuals that are mentally ill. We know that's true. It isn't just a place we keep people who have addiction problems. We know that's true. It's also becoming our nursing home in the United States. I mean, think about this statistic. You know, by 2030, the population of people 50 years or older, and I'm not saying 50 years is old by any stretch. It's going the percentage increase is 4,400% over the next 50 years past that point. We're literally going to have a prison system filled with old people. Why is that important? Well, it's important because old people don't commit crimes. They don't. They really don't. I mean, think about this. So you can tell that we have the same friends because I'm going to use my good friend Matthew Charles as an example as well. When Matthew was released and he went back, one of the arguments that was made was, this is crazy and this shouldn't be happening. And they asked the prosecutor to make a motion to get him released. It's in the power of the prosecutor. And the prosecutor basically stood up and said, no, because of this there's violent history there, so not going to happen. Yeah, okay, fine. When he was 20 years old, maybe there was. But he's in his 50s now. And I'm not saying you're old, Mr. Charles. People age out of crime for the same reason people age out of skateboarding. Who here skateboards? For the same reason that I don't match socks anymore. I just have a drawer of socks. If I'm too old to match socks, I'm certainly too old to go rob a bank. And I'm being tongue-in-cheek here, but the actual science tells us this is true. People do not commit crimes after a certain point. They're just too damn tired to do so. So one of the things that I think we really need to do, we need to have a better mechanism for ensuring people can age out of prison. A second look. It's really important in order to get some type of meaningful hold on our prison population. So one of the things that you're seeing in the States, and we haven't seen great movement here, but you're seeing states nibble at the edges every single year, and at the very end I'll say why that's important. But when you have states start to nibble, we can start passing laws. And one of the laws that we have been working on, and we have popped in a couple states, haven't had a lot of success yet, is actually just that, aging out. And what does it look like? Well, one of the things we do is compassionate release. I'm going to talk about in a second. The professor talked about it as well. But also things like there's a presumption for older adults that you can get out. And the government can come back and say, wait a minute, this guy murdered 30 people and ate their livers. Okay, I get it. Maybe that's not a person that we're going to age out. Maybe. But we also have the issue, but one of the big issues that we have is that decision makers, so prosecutors, judges, and parole boards, aren't educated on this science. They don't even get the facts of what actually plays into public safety, and that is something we need to change. So compassionate release, we talked about real quick. If anybody does not know what compassionate release is, it's basically what it sounds like. You get released because of some circumstance surrounding your life. Every state, I can't go over the states, every single state except Iowa has some type of compassionate release program. It could be exactly what the professor said of you have an individual that's becomes a single parent because somebody dies, or multiple different reasons. Most often it revolves around health issues. Most often they want to get rid of people that are unhealthy because they're expensive, but that's a different conversation. But it is disturbing how infrequently compassionate release is used. FAM has an incredible report on this. They go state by state by state and looks at every single state and how a compassionate release is used. So how few people? Well, Pennsylvania is not required to report statistics, but there was a report that came out and said between the years of, in a 6-year period, they released 9 prisoners under compassionate release. Really? 9 in 6 years? In Kansas, it was 7 individuals in 7 years, so about 1 person a year. That is insane. That is the definition of insanity. So we need less strict rules, but more importantly, what we need is very, very clear rules to understand, because what is the problem with most of the compassionate release statutes around the country is that there's so much vagueness involved that when, tie always goes to the prison in the criminal justice system. So if there's a tie, the DOC is going to win. And that is the way it's always played out. So that is some of the movement we're seeing in the states is more robust laws revolving around compassionate release, and I think that we'll see movement there soon. Another area I'm going to talk about is proximity. This is not really a movement in the states, but it's something I really care a lot about, and I'm absolutely, little side footnote there to Brian Stevenson. But there needs to be proximity between those who have power in the criminal justice system and those that are incarcerated. And specifically, we need prosecutors to understand the consequences of their actions. We need legislators to understand the consequences of their actions. I was a prosecutor for 9 years. I never visited a prison. Never. I never did. I was never invited to. I could have gone. I guess I wanted to. It just wasn't part of my job as an AUSA. I just didn't see it as something that I would do. So let me tell you a really quick story, because everybody loves stories. One of the biggest case I ever worked on, the most important case I ever worked on, was a human trafficking case. And the reason it was so important is because we indicted the John for a conspiracy to commit human trafficking, the John, the customer. And that's never been done before, or at least we never found it that has ever been done before. So instead of getting a charge for having sex with a minor, he got conspiracy to commit human trafficking. There was a lot of things that went into this case. We knew that he knew. I can give you the details offline if you want. So I always bragged about this case. It was a big deal for me. It was my feather in the cap case. But when I was teaching law, 1L asked me, I said, well, what about the pimp? What happened to the individual that was the trafficker? And I was like, oh my God, I don't remember. I can't remember. So I went back and looked, and he basically got a life sentence. Life sentence, like it's 75 years. And as I started to dig through, I started to look, and I saw his birth date. He was 19 years old. Life sentence at 19 years old, that I was part of. So do we need to have escape valves for somebody like that? Well, I don't know. I mean, there's some people in this room that probably hear that and say, okay, he was trafficking children for sex. That might be a reason you have a really long sentence. I hear you. And I might even agree with you. But if you look at the brain science, which is, this ties back to second looks, that's the come around, right? We know that individuals between the ages of like 13 and 21 have basically the same brain chemistry as 21 to 24. We don't really become grown-ups, and I mush those numbers together a little bit, so don't crucify me. But it isn't until like 25 that we're grown-ups. I have a 20-year-old son, and I was just telling the professor that he's brilliant. He's getting a degree in physics. And then I saw a loan that he co-signed for his new girlfriend for a car. Are you kidding me? He's been dating this girl for 2 weeks. Are you crazy? I mean, brilliant kid, dumber than a box of rocks. And I think about this a lot because, we have the Supreme Court case in Roper that said you can't put children for life sentences, but you can put a 19-year-old in prison for a life sentence. No problem. Check, done it. I know how that movie, I've seen the movie, I know how it ends. So I think we need more mechanisms for these types of second looks. We need to have real systems. It's a 15-year mark? Okay. It could be a million different things. You can have, every single penal code can have some type of sunset built into it that automatically triggers these second looks. There's lots of ways of doing this, and the states are doing them. But I think about this kid often, right now he's about 28 years old. I have no idea what he's doing at all. But I think about it. What if he started the mentor program in the prison he went to? Okay? What if 10 years from now, 38, he starts the reentry program and he is the one helping people, get their GEDs and their college degrees and reenter back into society? What if at 48, 58, he writes a novel that wins the Nobel Prize for Literature? Does he still need to be in prison for a life sentence? I mean, I don't know. I can't answer that question right now. But I do think that these are the hard questions we have to answer. So very briefly on what is going on in the state. So I'm going to say something that's going to sound really depressing, but then I'm going to tell you there's actually some hope behind it. We had lots of criminal justice bills that have passed across the country that have added these types of second looks to them. But since the first step has been enacted, we have seen this new flurry of types of actually the one in Florida called itself the First Step Act. And so we've seen Arkansas, North Carolina, Illinois, Rhode Island, Washington, California, New Jersey, Oklahoma, and I just found out today California is introducing a new bill tomorrow that's going to give judges discretion to reopen cases for nonviolent drug cases. And here's the bad news, is that none of those bills passed. None. But, well, one of them is still pending, but it's not going to pass. But I will tell you that I worked the First Step, we worked 4 years. I worked on that. It was called something different. There was a different Congress. There was a different president, much different president. And it took years of working. If Mark Levin, one of my closest friends, you guys saw him speak yesterday, when he first started working bills in Texas, they all failed. It took years. And the hope that I have right now is that we're seeing this new robust groundswell that I think will trickle down. I know people on the left don't like that phrase, but it works here, to actually have meaningful reform. And I'm really hopeful that these are happening because, we're going to be judged as a society someday, and I quote Gandhi, you judge a society by how it treats its weakest member. And we treat our weakest member very, very poorly. And I really hope that we as a society are actually coming together to have these second looks, to have a real justice system that is fair and, treats people like they're our neighbors. So thank you for your time.
Hello everyone. I'm not going to stand up. I hope you guys can pay attention. If you can see me, I think I can see everyone. My name is Marilyn Mosby. I'm the State's Attorney for Baltimore City, and I am honored to be up here with this esteemed panel. And one of the things that really stands out for me is we're talking about the First Step. I know that in New York, they have the Second Chances Amendment. The rehabilitation in the federal system and the effects that it has on mass incarceration, we know is rather minimal. I just had the privilege of going to Germany and to Portugal with several of my colleagues from across the country, some of the most progressive prosecutors. And what I was incredibly struck by was that at the core of not only their criminal justice system, but their corrections policies, is the preservation of human dignity, compassion, and respect. And I was struck because it is legally they have to rehabilitate their citizens. And it struck me because that's totally opposite from what we do in the United States. So we talk about the First Step and we talk about, this need to rehabilitate in the federal and in the state side. And we're excited. And to be honest with you, I'm optimistic and I'm excited that we're even having this conversation. But when you look at the recidivism rates, when you look at the violence, when you look at all of the statistics that would indicate that they're doing something right in other countries for far too long, and for decades, we've been getting it wrong. And it's taken us about 4 decades to get where we are, and how do we correct it? So when I look at it from the state side, where I'm excited about First Step, and before First Step in the state of Maryland, we had our Justice Reinvestment Act that we passed. And it gave that same sort of hope and opportunity and chance of transformation for those that we have to understand are coming back out into our communities, right? And as a prosecutor, we look at things from a public safety lens. And we cannot talk about corrections. We cannot talk about public safety in this country without talking about corrections. Let's get that clear. Most of the individuals are coming home. And even those that are not still deserve to be treated with human dignity. So we had the Justice Reinvestment Act and its reform of sentencing, community supervision, treatment capacity in Maryland. We expanded the eligibility for geriatric and medical parole. But we still have very limited sort of options in Maryland when it comes to second looks. We have the executive modifications that we can do, of course, in pretty much every state, parole and pardon and commutation. But what I think is really interesting is that in the state of Maryland, we have motions for modification. And these motions for modification, Rule 4345, revisory power of the court, upon a motion filed within 90 days after imposition of a sentence, and this is if in district court an appeal has been perfected or dismissed, and in circuit court, whether or not appeal was filed, the court has revisory power over the sentence, except that it may not revise the sentence after the expiration of 5 years. So as long as you file within 90 days, and as long as you schedule that hearing after the imposition of those 5 years, right, the original sentence, then you have the ability to, the court has the ability to modify, to reduce, to correct, or to vacate a sentence. Unfortunately, we haven't used what we have on the books for excessive sentences. What I can tell you is that from our understanding in the data, we've all heard how the data nationally is horrible. We are having a real difficulty even since the passage and the enactment of the JRA in collecting data. But in my knowledge, there's not been a single instance where a judge has expressly granted relief for excessive rehabilitation in light of rehabilitation. So there's for excessive sentences. There hasn't been an instance where a judge has gone on the record and said, I am reducing your sentence, I am modifying your sentence because it is excessive. So what are we doing? The enactment of this type of legislation is very much needed. We can either enact legislation that explicitly states that this is for excessive sentences. We can model, as Professor Berman has indicated, create and advocate for legislation that we go down to Annapolis and ask that we model after the model penal code, where you go before a judge and after 15 years in prison for all offenders, they would be able to say why they think that they've been rehabilitated to the point, at least to get a review of their sentence. And when you look at like Germany and Portugal, the maximum sentence that you can get in Germany is 15 years. The maximum sentence that you can get in Portugal is 25, regardless of the offense. Juveniles, that they hardly ever impose a maximum sentence on juveniles, which is, again, that 15 years. So before I go into some of the barriers, I really think it's important for us, as we're talking about excessive sentencing, it should not just be measured by the terms and the number of years imposed, but rather excessive sentencing should be measured by the types of crimes we're incarcerating people for. It should be measured by the extent and the conditions of confinement and our lack of empathy for those humans that we're confining. Now, my colleague already indicated that there should be some sort of connection between those with power and the correctional system and utilizing that power. But one of the things that I think that we should be focused on, and this question was asked yesterday, and it kind of bothered me to the extent that it was asked, how do you get people to care about criminals? You guys remember that question? And what I thought in my mind at that moment was, why don't we care about criminals? And I think the reality of the situation is that in the United States, we have to have some sort of recognition, right, and acknowledgement. There's a difference between the two. Recognition and acknowledgement start with recognition of the history and the legacy of slavery and the context of the legacy of racial tolerance in this country, which has allowed for non-criminals, right, non-criminals, to be able to disassociate themselves or to have at least exhibit a lack of empathy for criminals. More often than not, we already know, are poor black and brown people. Now, I think the basis of this, if it goes all the way back to our historical context, we talk about the 13th Amendment of the United States Constitution, where we abolished slavery, but we know what the exception for that abolishment was. And if you need a reminder, and I'm in the room with a bunch of judges, I know you don't, neither slavery nor servitude, involuntary servitude, except as punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. So according to present law, even the most abhorrent act of dehumanization, which was slavery, is justified against who? Criminals. So that question that we hearkened back to yesterday, how do we get people to care about criminals? For far too long, we have not cared because we've been able to disassociate. We have not wanted to confront the reality of the situation. We have not wanted to talk about race when that really should be the starting point. So it's easy, very much like the mentality that rationalized 400 years of dehumanizing subjugation. Those criminals in our mind are not like us. So it's easy not to care about the effects and the collateral consequences of mass incarceration for 4 decades on families and communities, the excessive sentences imposed on the dehumanizing conditions of confinement that not only our criminals, and I say this in quotes, endure, but we heard today how their families also endure these conditions. So what do we have? We have a duty to be aware. As a prosecutor, I think it's incredibly important. We're the ones who decide who's going to be charged, what they're going to be charged with, what sentence recommendations they're going to make to the court. It's incredibly important for us to understand and to be aware of the reality of the sentences that we help impose, not just impact our discretion on the individuals individually, but to understand that our discretion has public safety implications. We have to get it right. And so my colleague mentioned how he was a prosecutor for 9 years and had never even visited a jail. One of the things that I think is incredibly important is that I took my entire executive team to every Maryland correctional facility. We visited every single one of them. We not only went into the jails, but we were actually in the prisons. We went to the women's prison. We went to every single one we could go because, again, it's incredibly important for them to understand that. One of the things that we are attempting to do for all of my prosecutors, I have 217 and 403 employees, was to have mandatory training. And for the first time, we brought in the Equal Justice Initiative, Brian Stevenson's group, to do a racial and implicit bias training for my prosecutors so that they understand that awesome amount of discretion and how we all have implicit biases and how that may or may not show in their everyday decisions. One of the things that I think is also incredibly important for us to do is to start to humanize those that we've dehumanized. What does that mean? I told you in the beginning that I was struck that at the core of our criminal justice system and our corrections policies, we do not have the preservation of human dignity. And so I think that that is incredibly important. And we have to, in order to have that, we have to change the narrative. And how do you do that culturally? How do you change a narrative and the culture of individuals that have been dehumanized, stigmatized, and punished for decades? Well, I think having these types of discussions are incredibly important. But I also think that having those testimonies are incredibly even more powerful. And the same way that for very many poor black and brown people that were depicted on the television screens during the crack epidemic and the war on drugs, we have to start having, from a media perspective, those human stories to remind us that it could easily be our own, right? And those that we can relate to, and that's ethnically, religiously, racially. Because you'll note that during the war on drugs, we criminalized an entire sort of poor black and brown community, and we didn't really think much about it until we had the opioid crisis in America, right? And it started to infiltrate outside of the urban municipalities in every urban city in America. We're now looking at it from a different perspective, and we're looking at it from a public health perspective, which we should have been doing all along. I think that we have to be intentional about transformational change and racial justice. People are resistant to change, but the more drastic you are, I've learned, the more results that you obtain. And people start to pay attention. We have to remind society of the rehabilitative solutions. I can just tell you that in January, I decided that I was not going to be prosecuting marijuana possession in the city of Baltimore anymore. Thank you. And the basis of that decision was not only is it there's no public health, not a public safety concern. It's counterproductive to limited resources that we have in the criminal justice system. We had 316 homicides in Baltimore City last year with a year-end clearance rate of 26%. But this was the most sort of impactful sort of decision for me in data that we were able to collect thanks to the American Civil Liberties Union, where there's been a disproportionate enforcement of these laws in the city of Baltimore. We know that there's no disparate use, but we know, based upon the data, that even after the decriminalization of marijuana, where the officers now issue citations for 10 grams of less of marijuana, right? And we knew nationally, you're 4 times more likely as a black man to be arrested for possession of marijuana in 2010. But then in the city of Baltimore, you're 6 times more likely. But even after the decriminalization of 10 grams or less, when you look at the citations that are being issued in 2015, 89% of the citations that they were issued to black people. In 2016, 94% were issued to black people. In 2017, 95% were issued to black people. And this was the most staggering statistic for me, is that we have 9 police districts in the city of Baltimore. And 42% of those citations came out of one district. Imagine what district that might be. The one that you saw during the uprising 3 years ago, the Western District where I live, which happens to be disproportionately impoverished and 95% black. And so what I've said as a prosecutor is that I'm not going to be complicit in the discriminatory enforcement of laws against poor black and brown people. But that's the kind of transformative change that we need across this country. We can also we've talked about it before, decarceration, ensuring that we identify individuals that don't need to be incarcerated. And finally, and I think the most important point in all of this, is the legislative advocacy. I created in my office a policy and legislative affairs division where we've gone down to advocate for laws that are impacting our communities for the past. And I've been in office for 5 years. It feels like 50. But the one thing I can say is that they're not going to Obama me. I use hair dye. But that legislative advocacy piece is incredibly important. One of the things that we also did when I decided we weren't going to prosecute marijuana possession was we filed and we moved to vacate the convictions of almost 5,000 individuals. And the reason why we moved to vacate those convictions, and it was only 5,000, is because that was the only data that was available and accessible to us. Right? So we went back to 2011 and we pulled these cases. Any possession of marijuana case, we attempted to vacate. And we had to be creative because there is no legal mechanism for us to be able to do it. And so what we did is we did it on a basis of coram nobis relief, right? Righting an extraordinary wrong. And I told you the impetus of my decision was that discriminatory enforcement. And what we argued was that the enforcement of these laws were violative of the 14th Amendment Equal Protection Clause. Again, trying to think outside of the box. In the meantime, my policy and legislative affairs division went down to Annapolis to try to change the laws. And I'm grateful, but also humbled in the fact that I was only one. There's 24 state attorneys in the state of Maryland. I was only one of 2 to try and get a law that would actually allow us to vacate these convictions. And I have to tell you that this would give prosecutors the power to go in and vacate not only past convictions or crimes that are no longer a crime, it gives the prosecutors the ability to go in and to vacate convictions in those instances for actual claims of innocence. And last but certainly not least, those unforeseen circumstances that require where fairness and justice require it. If you all have been following what's been happening in Baltimore City, we had one of the largest police corruption scandals in the history of the country, where we had officers who were essentially targeting black men with backpacks and planting guns and drugs and evidence on them. They were then breaking into people's homes and redistributing drugs onto the streets. Well, we in my office has had to review thousands of cases. And because we didn't have a legal mechanism to vacate the convictions, some of our judges, and we would We would file the motions, we would argue the motions, we would reach out to defense counsel and say, hey, this is a conviction that we want to vacate based upon the fact that the materiality of this officer relies on his credibility. We know he has no credibility. And guess what? Despite the joint motions and about 20% of the cases that we filed, the judges were denying our request because they felt that there was no legal mechanism to do it. So there are ways in which, and I'm grateful, my Maryland State Attorneys Association actually opposed that piece of legislation, and despite their opposition this past legislative session, we had 55 prosecutors and police chiefs to sign on to the legislation, and we were thankfully able to get it passed. So those are some of the things, those are some of the ideas that I think we could go.
I think we have a few minutes for questions. 5, I'm told, so right in front here.
So I can just say that it was 20% of the cases. Most of the motions that we filed, the joint motions, mind you, this is defense and prosecutors who are agreeing that in the interest of fairness and justice, this should be vacated. It was 20% of them where they were denied. And it wasn't because they didn't believe that I honestly believe that the judges wanted to grant the motion but felt like they had no legal mechanism to be able to do it. And so that's the reason why we wanted to be able to advocate on the legislative side. But that's incredibly important. You have to, it's political, but you have to do both. You have to do, and you can be creative because 80% of them were. So 80% of them granted it. 80% of them granted it.
Well, and I'll just chime in, and again, this goes to where I hope we end up with the First Step Act in the federal system. If Congress or a state legislature has left something reasonably open, if there's a lawful basis for you to say, I think I can do this, and it's the right thing to do it, and let the legislature tell you, no, we didn't mean that to get done, right? I think we've gotten away as a society from a comfort with common law judging, where judges fill in the gaps of the law and move towards a just outcome, and then if it's not seen as going in the right direction, it's the legislature's authority to come in and say that's not where we want this to go, rather than, well, the legislature hasn't clearly said I'm allowed to do this, so I guess I'm not allowed to do this. And I think that in this setting especially is worrisome, though I see lots of judges and others with hands up. I want to get the hand here to get a few more questions in while we still have time.
Figure out how to turn on this mic. I'm the guy who asked a question of why anybody cares, and you answered a really important question for me, and the question, my question was, how were they able to pay me $1.50 a month when I worked in the kitchen at Sheridan Correctional Facility, Federal Correctional Facility, and now I know why. You know what? I'm a former lawyer, and the reason I'm a former lawyer is because I was a guest of the BOP for an extended period of time. So this California State Bar doesn't want me to practice law anymore. But so I've been out since July, and I came here because Olive helped me in some regards. You know, while I was there, helped me and helped my family. And I'm one of the lucky ones because my family stuck with me. And, you know, I have 2 kids, one of them who's going to school here and is actually at this conference. But you know, I have comments to all of you guys, and I can't tell you how incredibly frustrating it is listening to, you know, what you're all saying. And you know, what you're saying is, you know, if you know, there's a provision in the law to do things. Yeah, there's a provision in the law for compassionate release. It's never going to happen with the BOP involved, because until the BOP, until the prosecutors, until the FBI or or whoever the investigators are, and until the judges stop treating us like their enemies, nothing will ever change. Until they start treating us like human beings and individuals, nothing will ever change. And I'm not suggesting that all judges are like that, but I'm suggesting that some judges are like that. Everybody at the BOP is like that. All the prison guards and anybody who controls you at the BOP does treat you as their enemy, and they will express that willingly. So all I'm suggesting is this is wonderful. There's no compassionate release because nobody's compassionate. I know that it sounds funny, but I'm dead serious.
And I would just caution, I'm not at any point going to try to like demonize judges, right? Like at the end of the day, it's not a judicial sort of issue. This is a systemic issue.
I agree.
This is the way that the core of our criminal justice system and our corrections policies have led us here. So it's not individual judges. I think it's more of a systemic issue.
Well, but I disagree with you because and it goes to the randomness of the system. Who is your prosecutor? Who is your judge? Because if you get unlucky like I did, and I had the trifecta of a bad FBI agent and a bad federal prosecutor who came in at the end and wanted to prosecute me when the first person didn't, and a judge who, as soon as he was appointed, my lawyer said, "Oh shit," nothing good can happen. So I'm just telling you, as somebody who was a lawyer for 30 years outside of the criminal justice system, I was an entertainment lawyer, and I could not possibly believe in my lifetime that the system could work the way it did. It's pretty sad.
I got a hand over here. Thank you for your comment.
Sorry it took so long.
Okay, we got 1 or 2 seconds more, and then if people need to go on, go ahead.
So I have a quick question. So with the compassionate release, there is this tension between speaking about elderly people that they're not likely to commit crimes and therefore should be released, versus speaking about juveniles that their brain is not fully developed, and therefore we should be lenient, because there is that tension there, because juveniles, you can use that same rationale to say that juveniles are more likely to be committing crimes, therefore shouldn't we be harsher in treating them, and maybe use a flip argument when speaking about elderly folks. So I'll just be interested in hearing from the panelists how you deal with that tension.
Well, I mean, I think that, sure, there's a tension, but I mean, the reason that we treat juveniles different is because we say they're less culpable. We have decided as a society and said, if you're under the age of 18, you're less culpable. And so I studied the German criminal justice system a lot. And everything that she said was spot on. They also don't treat juveniles. The juveniles doesn't start at 18. It's like early 20s.
It goes to 24.
Yeah, 24. So I understand there's tension, but what I'm saying is that we should actually say, as a society, that when your brain basically makes you stupid, maybe we shouldn't treat you as if you're fully culpable. And I believe that. I think that if you were at that stage in your life where you're still, they did a study that looked at like 16-year-olds and studied their brains, and then it is the same chemistry of people who have serious bipolar disorder, the amount of crap going on in the head. So what I'm saying is, I understand there's a tension. I am just willing to live with the fact that if you're underdeveloped, and I think that's about 23, 24, we should treat you differently. Because we know that when you get to age 25, if you did do stupid things when you're 20, at the age of 25, you're much less likely to do those things because you're maturing. I mean, I did things at 20 that I would never do.
And I do think you could reframe it as people change over time. It doesn't even need to be focused on age per se, right? There's lots of things that make people change over time. People who get out of the throes of addiction become different that can be extraordinary and compelling in a different kind of way. And I think that's really where, at its core, the argument is a failure of our system to even respect the prospect of change, however defined, is one that leaves us in the state we're in, which is people over-incarcerated and not attentive to things that over time we get righteously more attentive to. I'm going to let Kara have the last word because we got to finish up.
Hi, thank you for letting me ask this question. So I'm looking at geriatric release, and I know that a lot of states there's been some bills floating around, and they all seem to cut the line at 65, and I've been having this conversation a lot, and I really think the line for consideration for geriatric release should be at 50. What is your experience in those conversations around age and what the cutoff should be?
So there are states that actually don't even have an age. They basically just, the process evaluates each individual individually. But you're right, if you're not over the age of 65, I can count on my fingers how many cases I've ever even heard of that have gotten release, any type of relief. So my personal opinion is that you should make a public safety analysis. It should be individualized analysis for that individual person looking at criminal history. I'm okay with taking that as part of the consideration. But if you committed a crime at 45 and now you're 50, well, that isn't the same to me than if you committed a crime when you're 20 years old and now that you're 50. I think a lot of these things, that's why there needs to be an individualized second look at these cases. And it doesn't have to be anything really sophisticated. It can't be vague because Ty always goes to the prison.
Right, and again, you do this in a nuanced way, effectively, a presumption after 65, but available after 50, but one of the factors to be considered is the percentage of sentence served, right? So again, somebody in at 25, now getting to 50, I think good argument, like Arthur said, somebody in at 45, looking at 50, it's a little bit different.
And if you stab 6 people throughout your sentence, well, maybe you're not a good candidate for that. But I think a lot of things kind of play into that.
Well, thank you, panel. Thanks here. We got